meeting of the Human Rights Committee. We're here to consider the periodic report of Hong Kong, and in the first instance, the permanent representative of the People's Republic of China, His Excellency Ambassador Liu Zhenmin, is going to present the Hong Kong Autonomous Republic delegation and introduce us to our future task. You have the floor, sir.
Mr. Chairman, I'm very happy to attend the meeting on behalf of the Chinese government. The government of the People's Republic of China restored sovereignty over Hong Kong on July 1, 1997, and set up Hong Kong's special administrative region according to the stipulations of Article 31 of the Constitution of the People's Republic of China. According to the policy of one country, two systems, and the basic law of Hong Kong Special Administrative Region of the People's Republic of China, HKSAR is a local administrative region of People's Republic of China, enjoying a high degree of autonomy and is directly under central government of China. The central government is responsible for the defense and the foreign affairs of HKSAR, and HKSAR has power of administration, legislation, and independent judicial power and final adjudication. The experience of the past 16 years has proved that the policy of one country, two systems has been a success. It has promoted the development of Hong Kong, maintained its prosperity, and won the support of both the people of Hong Kong and the mainland. According to relevant stipulations of the basic law of HKSAR of the People's Republic of China, relevant provisions of the International Covenant on Civil and Political Rights, as applied to HKSAR, remain in force after July 1, 1997, and should be implemented through the laws of the HKSAR. At the present, China is not yet a party to the covenant. However, in order to give full expression of the principle of one country, two systems, so that Human Rights Committee and international community can better understand the implementation by HKSAR of the relevant provisions of the covenant applied to HKSAR, Chinese government already transmitted to the Human Rights Committee, respectively in July 1999 and January 2005, the first and second periodic report of HKSAR of the People's Republic of China on the implementation by HKSAR, the relevant provisions of the covenant as applied to HKSAR, and successfully went through the review of the committee. In April 2011, once again, the Chinese government transmitted to the Human Rights Committee the third periodic report of HKSAR, prepared by the HKSAR government. The HKSAR attached great importance to the review of its third periodic report. With Ms. Zhang Chunyao, Permanent Secretary for Constitutional and Mainland Affairs, as its head, the delegation of HKSAR has come to Geneva to participate in the review of its periodic report by committee. The head of the delegation will make a detailed presentation of the report and reply to questions that may be raised during the review. I'm sure that you, Mr. Chairman, and all members of the committee will give full support to Ms. Chang and her colleagues in her colleague. And I'm also quite sure the colleagues of the Hong Kong delegation would also support the chair in her work. Thank you, Mr. Chairman.
Thank you very much, Your Excellency. I noticed that you said that the People's Republic of China is not yet itself a party to the ICCPR. It would be very nice if in a not too distant future we had the benefit of even that possibility of your presence here next time. Yes, of course, we're going to give a warm welcome to Ms. Chang and her colleagues, and we very much look forward to the constructive dialogue that I know will take place on the basis of the experience of the previous constructive dialogues that we've had. Thank you very much, Mr. Ambassador.
Thank you, Mr. Chairman. Thank you. Wish you all the best.
Thank you.
Thank you.
Two. So, Ms. Chang, I now give you the floor to introduce the third periodic report of the Hong Kong Special Administrative Region to the Human Rights Committee. You have the floor, ma'am.
Thank you, Chairman, distinguished members. As the Permanent Secretary for Constitutional and Mainland Affairs of the Hong Kong Special Administrative Region Government of the People's Republic of China, I see it a great honor to have this opportunity to address you on the implementation of the International Covenant on Civil and Political Rights in the Hong Kong SAR. First of all, I wish to thank Ambassador Liu, Permanent Representative of the People's Republic of China to the United Nations, Office at Geneva and other international organizations in Switzerland, for making the necessary arrangement for our attendance and for his introductory remarks made just now. The Hong Kong SAR is fully committed to the protection of human rights. This commitment has been upheld firmly and across the board by all our government bureaus and departments. I have with me today the key representatives, and they are Mr. Frank Poon, Solicitor General, and his colleague, Mr. Godfrey Kan, both from the Department of Justice, Mr. Lau Guanghua, Under-Secretary for Constitutional and Mainland Affairs, and Mr. Billy Wu, Principal Assistant Secretary for Security, and his colleague, Mr. Patrick Hodson from the Hong Kong Police. Chairman, as we see it, our submission of periodic reports to your committee, the subsequent response to the committee's list of issues, and the hearing process itself is a valuable opportunity conducive to the promotion of dialogue between the Hong Kong SAR government and the international community. In the process of compiling the third report in 2010, we have widely consulted members of the Legislative Council, NGOs, and interested members of the public. Such consultation processes and exchanges have also helped arouse our community's general awareness and interest in the covenant and human rights issues. I wish to express our appreciation to the committee for your list of issues in November last year, further to our submission of the third report. The questions raised in the list have given us the opportunity to provide clarifications and updates to some key areas after the finalization of the third report in 2010 and its formal submission to the committee in April 2011. I would like to take this opportunity to highlight a few specific issues which, in our view, help illustrate our government's commitment to making continuous and positive progress in safeguarding human rights. Allow me to begin by elaborating on some notable achievements made since the second report in 2005 with regard to the enactment of specific legislation against race discrimination, introduction of a statutory screening and appeal mechanism to process torture claims, and major enhancement of legal aid services in the Hong Kong SAR. In 2006, the committee expressed concerns at the lack of specific legislation to combat racial discrimination. I am pleased to inform the committee that the Race Discrimination Ordinance was enacted successfully as the law of Hong Kong in July 2008, after public consultation and detailed scrutiny by the Legislative Council. The new ordinance came into full operation in 2009. The Race Discrimination Ordinance aims at protecting the rights of individuals against discrimination, harassment, and vilification on the ground of race. Racial discrimination is in prescribed areas of activity, including education, employment, and provision of goods, services, facilities, and premises, are rendered unlawful under the ordinance. The ordinance also prohibits other unlawful acts relating to racial discrimination, including discriminatory practices and advertisements, aiding, instructing, or procuring others to discriminate, as well as vilification. Another major improvement or milestone since the previous report in 2005 is the much enhanced screening mechanism for torture claims, which was since been underpinned by statute. To ensure that the screening procedures would meet high standards of fairness, the Hong Kong SAR government introduced significant improvement to the administrative screening mechanism in December 2009. After its successful operation and pursuant to a comprehensive review, the enhanced mechanism was further underpinned by legislation enacted in December 2012. Under the statutory mechanism, each torture claimant is guaranteed reasonable time to establish and submit a claim. After the claimant has submitted detailed grounds of the claim and supporting facts in a specified torture claim form, the Immigration Department, as the authority, will arrange an interview with the claimant so that he or she may volunteer further information and answer questions relating to the claim. The Immigration Department's decision on the torture claim and reasons for the decision will be given to the claimant in writing. Under the statutory screening mechanism, a claimant who feels aggrieved by the Immigration Department's decision has the right to lodge an appeal to the Statutory Torture Claims Appeal Board, which is an independent body comprising former judges or magistrates. The Appeal Board may decide to hold an oral hearing if it considers that the appeal cannot be justly determined otherwise. Throughout the process, torture claimants have ready access to publicly funded yet independent legal assistance. Since the implementation of the enhanced screening mechanism for torture claims in 2009, 99% of the torture claimants have applied for, and all of them were provided with, this free legal assistance. The publicly funded legal assistance has been operated by the Non-Government Duty Lawyer Service, under which over 260 barristers and solicitors in private practice who have received prior training on handling torture claims are put on a roster to provide legal assistance to claimants throughout the entire screening process. The publicly funded lawyers will assist their claimant clients to prepare and complete the torture claim form, attend interviews with the Immigration Department, assess the merits of appeals if their clients so wish, and during appeals, prepare submissions for the claims and represent the claimants at the oral hearing, if any. As required by the legislation, the Immigration Department must consider each claim on its own merits and take into account all relevant considerations in deciding on the torture claim, including the existence in the alleged torture risk state of a consistent pattern of gross, flagrant, or mass violations of human rights. A claimant may not be removed from the Hong Kong SAR to another country where there are substantial grounds for believing that the claimant will be in danger of being subjected to torture there. In addition, the Hong Kong SAR government, on humanitarian grounds and in collaboration with a reputable NGO, offers comprehensive in-kind assistance to torture claimants who cannot meet their basic needs whilst their claims are being processed. This is to protect the claimants from going into destitution. The assistance offered covers temporary accommodation, food, clothing, other basic necessities, appropriate transport allowances, necessary counseling and medical service. The third area of major development that we wish to highlight to the committee is the enhancement of legal aid services that are available for judicial proceedings. Recognizing that the right of access to the courts is an important pillar in protecting the wide range of rights under the Covenant, the provision of legal aid is an integral part of the Hong Kong SAR's legal and judicial system. Our policy objective is to ensure that no one with reasonable grounds for pursuing or defending a legal action will be denied access to justice because of lack of means. Pursuant to this objective, we have significantly widened the scope of legal aid services in recent years. In May 2011, the Hong Kong SAR government increased the financial eligibility limits of the statutory ordinary legal aid scheme and the self-financing supplementary legal aid scheme substantially. The financial eligibility limits for the statutory ordinary legal aid scheme was increased by 48% in one go from Hong Kong dollar 175,800 to Hong Kong dollar 260,000, while that for the self-financing supplementary scheme was increased by over 160%, from slightly less than Hong Kong $500,000 to Hong Kong dollar 1.3 million. As an illustration of the impact of the uplifted supplementary legal aid scheme, the number of approved applicants who benefited from the enhanced supplementary scheme has increased by about 40% in 2012 as compared to 2011. Also, in 2012, we expanded the scope of the supplementary legal aid scheme to cover a wider range of professional negligence claims and monetary claims against offenders in the sale of first-hand residential properties, and injected Hong Kong dollar 100 million into the supplementary legal aid fund to support the operation of the expanded scheme. We will monitor progress and invite the Independent Legal Aid Services Council to conduct a further review on the scope of the supplementary legal aid scheme in the light of the experience gained. Chairman, I would now like to share with the committee developments in two areas where the committee has expressed observations in the past, namely constitutional development and equal opportunities for sexual minorities. These issues are close to our hearts as well and are indeed subjects of ongoing public discussions in Hong Kong. First, constitutional development. The Hong Kong SAR government has continued its determined efforts in taking forward the Hong Kong SAR's constitutional development in a steadfast manner. Since the submission of our second report in 2005, the timetable for implementing universal suffrage in the Hong Kong SAR has been laid down and made known to the public. According to the decision adopted by the Standing Committee of the National People's Congress of the People's Republic of China in December 2007, universal suffrage may be implemented for electing the chief executive in year 2017. After that, universal suffrage may be implemented for electing all members of the Legislative Council. The decision of the Standing Committee of the National People's Congress is a very important milestone, as it provides a clear time frame to take forward the Hong Kong SAR's constitutional development towards the ultimate aim of universal suffrage, as provided for in the Basic Law of the Hong Kong SAR. In addition, the reform package put forth by the Hong Kong SAR government for the election of the Chief Executive and the Legislative Council in 2012 was passed by a 2/3 majority of all the members of Legislative Council, given consent to by the Chief Executive and endorsed by the Standing Committee of the National People's Congress in summer of 2010. For the first time since the establishment of the Hong Kong SAR in 1997, we have completed the constitutional procedures required to amend the electoral methods for the Chief Executive and the Legislative Council. The two elections were held successfully in March and December last year, respectively. It is perhaps worth noting that the turnout for the geographical constituencies of the Legislative Council election involved 1.83 million registered voters, which is a historic record high in our election records. The successful implementation of the constitutional reform package last year has greatly enhanced the democratic elements of the two electoral methods. In the case of the Legislative Council election, the number of legislators returned from the geographical constituencies and the number of legislators returned from the functional constituencies was each increased from 30 to 35, hence making a total of 70 legislators at present. Each of the 5 new functional constituency seats was elected through one person, one vote, among some 3.2 million registered voters who previously did not have a right to vote in the traditional functional constituencies. As a result, with 35 legislators returned from the geographical constituencies and the 5 returned from the new functional constituencies, close to 60% of all the seats in the Legislative Council have an electorate base of over 3 million voters altogether. In effect, every registered voter had 2 votes in the 2012 Legislative Council election, one for the geographical constituency and the other for the functional constituency. Regarding the local councils or the district councils, the government has just introduced an amendment bill to the Legislative Council in February this year to abolish all appointed seats of the Legislative Councils in one go, or rather, once and for all. Subject to the scrutiny and passage of the amendment bill by the Legislative Council, there will be no more appointed seats in the next term of the district councils when it commences in 2016. The Hong Kong SAR government is fully committed to attaining universal suffrage for both the Chief Executive and the Legislative Council elections in accordance with the Basic Law and the decision of the Standing Committee of the National People's Congress of December 2007. With the experience gained in the 2010 exercise, we will, at an appropriate juncture, launch public consultations on the election methods for the Legislative Council election in 2016 and the Chief Executive election in 2017, and initiate the required constitutional procedures accordingly. Last but not least, I would like to update recent developments in the area of equal opportunities for sexual minorities. As in many parts of the world, sexual orientation is a controversial subject in Hong Kong. This notwithstanding, the Hong Kong SAR government's position is clear that no person should be discriminated against on any grounds, including sexual orientation. We have been undertaking extensive public education and publicity programs to promote equal opportunities on grounds of sexual orientation, with a view to fostering in the community a culture of mutual understanding, tolerance, and respect. For the time being, there are ongoing and active public discussions, with different groups in the community expressing their strong support or intense opposition through heated debates and public demonstrations. The Hong Kong SAR government considers it essential that the community should have a rational and informed discussion in due course. We will continue to listen to different views from various sectors. We will also inject more resources, step up our efforts, and strengthen the work on public education and publicity. endeavoring to eliminate acts of discrimination against people of different sexual orientations in society. My colleagues have already started meeting different stakeholder groups and academics with a view to forging a consensus on the way forward. We do not underestimate the complexity and sensitivity of the issues involved. However, we believe that through rational discussions and consensus building, we will be able to find the best way forward for protecting sexual minorities. Chairman and distinguished members, I will end my opening statement here. With your permission, I would now like to invite Ms. Lau Guanghua, Under-Secretary for Constitutional and Mainland Affairs, to highlight the Hong Kong SAR's response to some of the key questions in the list of issues identified by the committee and the development since November 2012. Thank you.
Thank you very much, Madam Chang, and I now happily give the floor to Mr. Lau to continue with the summary of the responses. Thank you. You have the floor, sir.
Microphone.
SAR to provide information on the implementation of the ICCPR in Hong Kong. I will now highlight some areas in which the committee has sought further information through the list of issues stated in November 2012. I will quote the number of the questions as in the list of issues to facilitate cross-referencing to the list. In question 1, the committee expressed its concern on the dual role of the incumbent chairperson of the Equal Opportunities Commission, EOC. By the way, the incumbent's term of service will end later this month on 31st of March. The open recruitment process for a new chairperson of the EOC has been completed, and the Hong Kong SAR government has announced on the 5th of March the appointment of Dr. York Chow as the new EOC chairperson for a term of 3 years. We would like to underline that the recruitment process was done in a rigorous, open, and objective manner. An open recruitment exercise was conducted through an experienced human resources consultant, which provided independent expert assistance to the selection board. The selection criteria, which were set out in the recruitment advertisement, include knowledge, ideals, and passion in promoting equal opportunities and anti-discrimination, administrative experience and leadership, as well as good communication skills, etc. Furthermore, any candidate with disabilities was automatically given an interview. A total of over 120 candidates were considered by the selection board. The selected candidate, Dr. Chow, is an orthopedic surgeon by training, but has an impressive track record in promoting equal opportunities, particularly for persons with disabilities, as he has served on the Hong Kong Paralympic Committee and the Sports Association for the Physically Disabled and the New Life Psychiatric Rehabilitation Association. Furthermore, through his past appointment as a policy secretary in the Hong Kong SAR government responsible for medical, food, and welfare portfolios, Dr. Chow is conversant with equal opportunities for women and persons with different family status and has proven his administrative and leadership skills. The selection board considered Dr. Chow the most suitable candidate among all applicants. On question 9, the committee also asked about the number of cases that the Complaints Against Police Office, CAPO, investigations were not endorsed by the Independent Police Complaints Council, IPCC, and the reasons for that. Since the IPCC became an independent statutory body with the commencement of the IPCC ordinance in June 2009, it has been exercising its statutory powers to observe, monitor, and review the handling and the investigation of complaints against the police by CAPO. The IPCC has adopted a holistic approach in assessing and evaluating police actions and decisions in each complaint case by referring to police force procedural guidelines and manuals, case file records, and records of related court proceedings. The police have a statutory obligation to comply with the IPCC's requirements. From 2009 to March 2012, the IPCC has scrutinized some 15,000 investigation reports of reportable complaints. In general, the CAPO's investigations were endorsed by the IPCC. During this period, CAPO accepted over 4,300 queries or suggestions made by the IPCC and reclassified the findings of about 700 allegations. During this period, disciplinary proceedings or internal actions were taken against some 800 police officers in respect of 600 cases. These figures demonstrate the effectiveness of the two-tier police complaints handling system made statutory in 2009 in ensuring that complaints against police are handled in an impartial and independent manner. Relating to question 10, also on the independency of the IPCC, with the enactment and implementation of the dedicated Independent Police Complaints Council Ordinance in June 2009, the IPCC is now a fully independent statutory body with statutory functions and powers, including observing, monitoring, and reviewing the handling and investigation of reportable complaints by the police. As mentioned earlier, the police has a statutory obligation to comply with the IPCC's requirements. Under the ordinance, CAPO has a statutory obligation to submit an investigation report on each reportable complaint to the IPCC for rigorous examination, and the CAPO is required to address queries and suggestions from the IPCC arising from investigation reports. IPCC may also request and interview complainants, complainees, police officers, or witnesses during the review process. If the IPCC is not satisfied with the finding of a CAPO investigation report, the IPCC may request the CAPO to investigate the complaint. Only when the IPCC completely agrees that the complaint has been properly handled will it endorse the investigation report. The IPCC is also empowered to bring any case and its recommendations to the personal attention of the Chief Executive. The number of members serving the IPCC has been increased by over 30% from 18 to 24 in late 2010. The increased number of IPCC members will widen public participation in the IPCC and also ensure that the IPCC will continue to perform its oversight functions effectively. The 24 existing members of the IPCC, all non-official, are drawn from a wide spectrum of the community, covering 3 Legislative Council members as Vice Chairman, as well as the legal, health services, education, social welfare, communication, and commercial sectors, etc. In addition to IPCC members, a large pool of non-official observers, more than 100, also undertake scheduled or surprise visits to observe the interviews or collection of evidence by the CAPO during the CAPO's investigation of complaints. With the commencement of the IPCC ordinance in 2009, the number of complaints received by the CAPO surged by 58% from 2008 to 2009. This may reflect stronger public acceptance of and confidence in the newly established statutory IPCC. In response to the committee's concerns on human trafficking in Hong Kong under Question 14, we would like to reaffirm the fact that Hong Kong is not a source, transit point, or destination of transnational human trafficking activities. Nevertheless, our law enforcement agencies will uphold vigilance and continue with close collaboration with international agencies to exchange intelligence and keep abreast with the latest trend of human trafficking and skills in victim identification. Examples of these efforts are set out in paragraphs 14.8 and 14.9 of our response. The Hong Kong SAR government is also committed to protecting the well-being of foreign domestic helpers, as elaborated in our response under Question 15. In addition to receiving the same statutory employment protection as local workers under Hong Kong's employment ordinance, foreign domestic helpers are further protected by a mandatory standard employment contract prescribed by the government. The standard contract requires the employer to provide the foreign domestic helper with, amongst others, a wage not lower than the minimum allowable wage announced by the government and prevailing at the time the contract is entered into, suitable accommodation and medical treatment for free, and free return passage between Hong Kong and the helper's place of origin for each contract. Most of these benefits are not available to the local workforce, certainly not as standard contractual requirements. Furthermore, the minimum allowable wage, which was introduced in 1973 to protect foreign domestic helpers from exploitation, has been regularly reviewed, taking into account the general economic and employment situation of Hong Kong. The prevailing minimum allowable wage is 3,920 Hong Kong dollars and is applicable to all contracts signed on or after 20th September 2012. This level compares favorably with wages offered to foreign domestic helpers in other Asian economies. In the event that a foreign domestic helper considers that his or her statutory or contractual rights have been infringed, which cannot be resolved with the employer directly, there are ample channels for the foreign domestic helper to seek redress. On protection of privacy, to address the committee's interest in police videotaping during public order events under Question 17, we would like to reiterate that only those officers who have undergone appropriate training will be deployed for the video recording duty during public orders events. The training includes the understanding of the relevant laws and powers, use of equipment, purpose and procedures of the recording, etc. The police also has clear and stringent guidelines and procedures to handle the record materials, including their safe custody, proper handling, and timely destruction. We would like to clarify and confirm that even for the purpose of maintaining law and order, the police does not install any CCTV system in public places on a permanent basis. The committee may also wish to note that with technological advances, a field trial of body-worn video cameras was launched by the police yesterday. As the police has explained to the media and the community earlier on, cameras offer in some circumstances a more practical arrangement for policing purposes. The focus of their deployment will be for confrontational scenarios where a breach of the peace has occurred or is likely to occur, and their use is governed by stringent police guidelines. The use of body-worn video cameras is also seen in several overseas jurisdictions, including the US, the UK, and some European countries with positive outcome. Last but not least, the Hong Kong SAR government has been handling matters of right of abode and family reunion in accordance with the Basic Law. Relevant international conventions apply to Hong Kong and local legislations and policies. Pursuant to Article 22 of the Basic Law, for entry into the Hong Kong SAR, people from other parts of China must apply for approval. Mainland residents who wish to settle in Hong Kong must apply for a one-way permit from the Exit and Entry Administration Offices of the Public Security Bureau of Mainland China at the places of their household registration. Since the establishment of the Hong Kong SAR in July 1997 to December 2012, more than 760,000 mainland residents have settled in Hong Kong under the one-way permit scheme. Details of the relevant procedures are set out in paragraphs 22.2 to 22.5 of our response. Chairman and distinguished members, may I pause here for the latest developments in various aspects covering by the list of issues. We will be happy to elaborate on our work and answer any questions that the committee may have regarding the protection of human rights in Hong Kong. Thank you.
Thank you very much indeed, Mr. Lau. And thank you both for absolutely strictly making the kinds of presentations that will help our work go most smoothly, as well, of course, for the extensive written responses to the list of issues. With that, I now ask members to take the floor with regard to follow-up questions. The first on my list is Mr. Flinterman. Mr. Flinterman, you have the floor, sir.
Thank you very much, Mr. Chairman. Not so much for follow-up questions, but for questions in the light of what we just heard. Let me start by joining you in welcoming most warmly the delegation from Hong Kong SAR. It's almost exactly 7 years ago that our committee last met with a delegation from Hong Kong SAR. And I welcome this opportunity to assess through a constructive dialogue with the delegation the present status of the protection of human rights and fundamental freedoms as contained in the Covenant on Civil and Political Rights. And in that respect, I would like to express my appreciation for the report and for the replies to the list of issues, although the replies came in very late and gave us little time to prepare ourselves in the way we are used to. I especially appreciated that in the report the views of various commentators were referred to, which shows that the report is based on consultations with civil society organizations, but at the same time upholding the accountability and responsibility of the government of Hong Kong SAR for the contents of the report. Madam Head of Delegation, I would like to raise a few further queries under the issues 1 and 3 of the list of issues. And I would like to thank you very much in advance for the further information that you provided through your presentation this morning. First on issue number 1. After we last met in 1997, our committee recommended that Hong Kong SAR should consider the establishment of an independent human rights institution compliant with the Paris principles. You alluded to that in your presentation. From the report and from the replies to the list of issues, it's clear that Hong Kong SAR has given serious attention to this recommendation, and I appreciate that. But I deeply regret the outcome of that consideration process because the government of Hong Kong SAR has concluded that the existing mechanisms of protecting human rights has worked well and there is no obvious need to establish another human rights institution. End of the quotation. I have a few comments, and I would like you to consider those comments in your replies later on. But first, my first comment is that it is not only the Human Rights Committee 7 years ago that came to the conclusion that there is a need for the establishment of an independent human rights institution in Hong Kong SAR, but also for other human rights treaty bodies. And they have all called upon Hong Kong SAR to establish a national human rights institute. My second comment is that it is the Ombudsman of Hong Kong himself who made it clear through a very interesting report that in the system of protection of human rights within the context of Hong Kong SAR, there are important gaps that could be usefully filled by an overall human rights institute. And then next, an objective assessment of the powers of the existing mechanisms, such as the Ombudsman and the Equal Opportunities Committee, shows, in my opinion, that they indeed have limited mandates. For example, I had a look at the mandate of the Ombudsman. He doesn't have any powers to provide legal services, to provide legal advice, to provide legal aid, or to bring legal proceedings or issue orders. And neither has he the power to modify policies or to suggest the modification of policies that constitute a breach of human rights or to investigate the police forces. And I do think that the rejection of the idea of the establishment of a national human rights institute seems to be based on an incomplete understanding of the mandate of national human rights institutes as stipulated in the Paris Principles. And let me just quote the Paris Principles of 1992, adopted through a General Assembly resolution, unanimously adopted through a General Assembly resolution. A national institute, and I quote, shall have the following responsibilities: to submit to the government, parliament, and any other competent body on an advisory basis, either at the request of the authorities concerned or through the exercise of its power to hear a matter without higher referral, opinions, recommendations, proposals, and reports on any matter concerning the promotion and protection of human rights. And that may refer to any legislative or administrative provisions, as well as provisions relating to judicial organizations intended to preserve and extend the protection of human rights. Such reports may refer further to any situation of violation of human rights, to the preparation of reports on the national situation with regard to human rights. And we have missed such input from a National Human Rights Institute in our preparation for today's dialogue. And such a national institute, through its advisory function, may draw the attention of the government to situations in any part of the country where human rights are violated. These are just a few aspects of the mandate of a National Human Rights Institute. And even by referring in some detail to such a mandate, I think it's clear that also in your country, the establishment of a National Human Rights Institute may have an added significance in your efforts to protect human rights and fundamental freedoms. And my second question under issue number 1 relates to the Equal Opportunities Committee, which has a limited mandate restricted to investigation and conciliation efforts. It doesn't have enforcement powers. Moreover, I have a query about the composition of the Equal Opportunities Commission. The members of the Equal Opportunities Commission act in an independent manner, but it is of course also important that they can be seen to be independent. And in that respect, I was very pleased to hear your presentation about the recent selection of a new chair for the Equal Opportunities Committee. And my question would be, what steps will be taken by the government of Hong Kong SAR in first, from a substantive point of view, to strengthen the mandate of the Equal Opportunities Committee, and secondly, to preserve the independence of all members of the Equal Opportunities Committee, including the chair of the Equal Opportunities Committee. For example, would it be impossible in the future that the position of chair of the Equal Opportunities Commission could be discharged at the same time that that chair is the convener of the Executive Council? Now I come to issue number 3. And issue number 3 relates to the electoral system in Hong Kong SAR. And I was very pleased to hear that that particular issue is close to the heart of the government of Hong Kong SAR. It was in 2007, Madam Head of Delegation, that our committee recommended, and once again I quote, that all necessary measures should be taken whereby the Legislative Council is elected by universal and equal suffrage. It should be ensured that all interpretations of the basic law, including electoral and public affairs issues, are in compliance with, with our covenant. End of quotation. I do submit, Madam Head of Delegation, that that recommendation of 2007 is as valid in 2013 as it was in 2007. And that since 2007, maybe only very little progress has been achieved, and you were referring to that by the increase in the number of seats from geographical constituencies. But I was very pleased to read in various paragraphs of your third report that, and I quote from paragraph 320 of your report, that both the CPG, the Central People's Government, and the Hong Kong government are fully committed to attaining universal suffrage for the Chief Executive and the Legislative Council in 2017 and 2020. And that is repeated in the replies to the list of issues and questions. For example, in paragraph 3.1, and again I quote, that the Hong Kong government is committed to attaining the ultimate aim of electing the Chief Executive and all the members of the Legislative Council by universal suffrage. End of quotation. And now, like today in your presentation, no years were mentioned in the replies to the list of issues, but I take it that that paragraph and your presentation this afternoon should be read against the background of your report, of your third report. I have a few comments and questions in the light of what I just said. I think my first comment is that your commitment to attain the ultimate aim of electing the Chief Executive and all the members of the Legislative Council by universal suffrage in 2017 and 2020 reveals that also in your opinion the present electoral system is not fully compatible with the requirements of universal and equal suffrage as contained in your basic law and in the Covenant on Civil and Political Rights, Article 25. Second, my second comment is that given your full commitment, the full commitment of your government to universal and equal suffrage implies that maintaining the reservation to Article 25 seems to be redundant. And my question, therefore, is whether it is the intention of the Hong Kong government, Hong Kong SAR government, to withdraw this particular reservation. And in this respect, I hasten to add that, in my opinion, the view of the Human Rights Committee that this particular reservation to Article 25 by the UK in 1976 has lost its significance altogether once the Legislative Council in Hong Kong SAR was established. My third query in this respect is whether it would be possible for the delegation of the Hong Kong SAR to present a clear outline of what its understanding is of the main features of the concept of universal and equal suffrage. And in that respect, I would like to refer you to one of the committee's general comments, appropriately number 25, general comment number 25, relating to Article 25 of the Covenant, in which the committee has made an effort on the basis of its long-time experience in the examination of state reports and individual communications in relation to Article 25, to outline the basic aspects of Article 25. And let me tell you in that respect that the committee has come to the conclusion that in the more than 160 different states parties to the Covenant, there are more than 160 different electoral systems. There are many ways leading to a compliance with Article 25. But in order to be compliant, the main requirements of Article 25 should be fulfilled by any state party, and including by the Hong Kong SAR. And finally, on this very important issue, and once again I would underline that issue is close to your heart, and from the information before us, also close to the heart of the people of Hong Kong SAR, and that is that there are deep concerns about the delays in the introduction of universal and equal suffrage. And for that reason, I was very pleased to hear in your presentation earlier this afternoon that in relation to the Legislative Council, you did not refer to the year 2020, but to the year 2016, in which possibly an electoral system based on universal and equal suffrage and based on the requirements of Article 25 of the Covenant would come into being. And those, Mr. Chair, my apologies for taking the time, so much time, but it is an important issue. Those were my questions, further questions under issue 1 and 3. Thank you very much.
Thank you very much, Mr. Flinterman, and indeed they were important questions and no apologies are required. And I now give the floor to Mr. Iwasawa, next on my list. You have the floor, sir.
Thank you very much, Mr. Chairperson. I join my colleagues in extending a very warm welcome to the distinguished delegation of the Hong Kong Special Administrative Region of the People's Republic of China. I do not want to repeat what Mr. Flinterman said, but I like to underscore just one thing. In the report, in various places, it says some commentators express concerns, some commentators raise concerns, and then the report tries to address and respond to those concerns. It's very rare to see this kind of report, and it's very good. And I think it shows that the Hong Kong SAR government is addressing human rights issues seriously. This afternoon, I will ask questions on issues numbers 2, 4, and 5. And I start with question number 2, issue number 2. I take note with satisfaction that even though treaties do not have the force of law in Hong Kong, in general, the Hong Kong Bill of Rights Ordinance incorporates most of the human rights provisions enshrined in the ICCPR.
and people in Hong Kong can invoke the provisions of the ordinance, which are almost identical to those of the covenant. And I note with satisfaction, this is the information you gave us in the written replies, that there are around 1,000 judgments which included references to the ordinance. The government of Hong Kong SAR gave 3 examples of cases in which the court referred to the work of the committee in interpreting the ordinance, and the ordinance was applied to supersede conflicting laws. And I'm particularly pleased that the Court of Final Appeal commented that the general comments are, and I quote, a valuable jurisdictional resource, end of quote, in the adjudicative role of the committee. And could the distinguished delegation provide us with information as to whether the conflicting laws were eventually amended when they were found unconstitutional as being contrary to the ordinance? I note the fact that the Standing Committee of the National People's Congress denied the effect of 3 sections of the ordinance relating to the interpretation and application of the ordinance in 1997 on the ground that they contravened the basic law. I'm aware of the position of the government of the Hong Kong SAR that the non-adoption of those sections has no effect on the protection of human rights in Hong Kong. However, the non-adoption of those sections, in fact, works as if they were reservations to the covenant. And when a state party attached a reservation to the covenant, it is our usual custom and practice to ask the state to consider withdrawing the reservation. Similarly, I would like to ask what the government of Hong Kong SAR can do with regard to the non-adoption of the 3 sections of the ordinance. I understand that the Standing Committee of the National People's Congress can adopt interpretation of the basic law. In the absence of a court case in Hong Kong, could the distinguished delegation please explain to us what effect this power of the NPCSC has for the rule of law in Hong Kong? I'd like to move on to question number 4. I take note with satisfaction that the government of the Hong Kong SAR has combated discrimination through various measures, including the Race Discrimination Ordinance, the Sex Discrimination Ordinance, and the Disability Discrimination Ordinance. And I take note also that the Race Discrimination Ordinance was enacted in 2008. This was highlighted by the Madam Head of the Delegation in her opening remarks. And I take note that the Hong Kong SAR government issued administrative guidelines in 2010 to promote racial equality, and that the range of the guidelines will be extended this year. I have some questions in relation to these ordinances. With regard to the Race Discrimination Ordinance, another treaty body, the third, has identified several issues which need to be addressed, such as the definition of racial discrimination, which does not clearly define indirect discrimination with regard to language, and which does not include immigrant status and nationality among the prohibited grounds of discrimination. The scope of application of the ordinance, which only covers certain government activities and exercise. The 2 weeks rule, whereby domestic migrant workers have to leave Hong Kong within 2 weeks upon termination of their contract. And the absence of any official education policy for teaching Chinese as a second language for non-Chinese speaking students with an immigration background. In addition, I take note with concern that immigration law denies the right to permanent residency to foreigners who work as home helps, and most of whom are from Philippines and Indonesia, even after they have lived in Hong Kong uninterruptedly for 7 years. We have information before us that the Hong Kong SAR government is determined not to include new immigrants from mainland China as a protected group under the Race Discrimination Ordinance. I'm aware of the debate whether the new immigrants are of different ethnic group. However, if they face discrimination from local people, should protection not be extended to those immigrants as well? I'd like to ask if the Hong Kong SAR government has taken any steps to address these issues, or if they have any plans to take such steps in the future. The effective implementation of the guidelines can be achieved through an effective monitoring system. According to the written replies, the Equal Opportunities Commission has received 180 complaint cases lodged under the Race Discrimination Ordinance and handled 1,400 inquiries on specific incidents related to the ordinance. However, according to information provided by an NGO, the Equal Opportunities Commission has no power to deal with complaints under the Basic Law and the Bill of Rights Ordinance, and people discriminated against by the government therefore cannot seek redress through consultation of the Commission. And the Race Discrimination Ordinance excludes discrimination on the grounds of nationality and language. Could the distinguished delegation please comment on these allegations? The Hong Kong SAR government indicated an intention to amend the Sex Discrimination Ordinance and the Disability Discrimination Ordinance in response to the Equal Opportunities Commission's proposals in October 2000. However, the government so far has not implemented the Commission's proposals except for the amendment of the definition of sexual harassment. Could the distinguished delegation explain why amendments of the ordinances have not materialized? I now move on to question number 5. In the opening remarks today, Madam Head of the distinguished delegation, Ms. Chan, said, and I quote, "The Hong Kong SAR government's position is clear that no person should be discriminated against on any grounds, including sexual orientation." End of quote. We are very pleased to have received this strong commitment on the issue of sexual orientation from the head of the distinguished delegation this afternoon. And I take note in the written replies to the list of issues and in the opening remarks, the distinguished delegation explained that it has instituted public education and publicity programs with a view to fostering a culture of mutual understanding, tolerance, and mutual respect in order to eliminate discrimination against people of different sexual orientation and transgendered persons. However, there is as yet no legislation prohibiting discrimination on the ground of sexual orientation. The Bill of Rights Ordinance is not helpful in this respect because it only covers the public sector. When the discrimination happens in the private sphere, the discrimination is not subject to judicial review by the court. And in the written replies and in the opening remarks of the head of the delegation, the distinguished delegation explains the lack of legislation by the existence of diverse views on the issues at present. However, I would like to stress that according to the awareness survey conducted by the Equal Opportunities Commission in 2012, 60% of the respondents considered the introduction of such legislation very important. In addition, discrimination on the ground of language remains a serious issue in Hong Kong. Ethnic minorities who are usually not proficient in Chinese face various difficulties in society. This is because although both English and Chinese are official languages of Hong Kong, government services and information are often only in Chinese. And according to the Equal Opportunities Commission, there is less than 1% of local Hong Kong undergraduates which are from ethnic minorities. And tomorrow morning, when we discuss the question of ethnic minorities, I'd like to come back to this issue again. In addition, although there is a free legal advice scheme in Hong Kong, there are no interpretation services or leaflets in minority languages. While there is a duty lawyer scheme in Hong Kong, we're told that duty lawyers are reluctant to defend ethnic minorities and tend to persuade them to plead guilty. In the legal process, interpreters often misinterpret the words of ethnic minorities and dissuade them from speaking in details. And we are also told that job opportunities are limited for residents of the lower and middle class who do not read or write Chinese, and many small enterprises have application forms and conduct interviews only in Chinese. And we are also told that many social workers in Hong Kong are unwilling to serve ethnic minorities. And according to the information before us, the government of Hong Kong SRR did not employ interpreters for South Asian or Southeast Asian languages in the 2011 census. Could the distinguished delegation please comment on these allegations? Does the government of Hong Kong SRR have any plans to address these issues? Thank you very much, Mr. Chairperson.
And thank you, Mr. Owasawa. I now give the floor to Mr. Newman. You have the floor, sir.
Thank you, Mr. Chair. And may I add my own warm welcome to the distinguished delegation from the Hong Kong Special Administrative Region. And I look forward to our constructive dialogue. I thank you for the information that you've provided so far and for the information that you will provide. I will be discussing issues numbers 6, 10, and 11 on the list. Question 6 relates to the political participation of women. As I understand the situation, partly from the report and the replies, also from the Hong Kong SAR's report to the CEDAW Committee. Less than 20% of the candidates who were elected to the Legislative Council and District Councils in the elections in 2007 and 2008 were women. Could I ask the distinguished delegation to reflect on the causes of that underrepresentation and what might be done to increase the political participation of women in that electoral sphere? For advisory and statutory bodies, which play an important role in the Hong Kong SAR, there was a 30% benchmark for the appointment of women to those bodies. And the information that we've received in this report and the replies suggests that that 30% benchmark has been met on average across the entire set of advisory and statutory bodies. But the Equal Opportunities Commission points out that more than 100 of the advisory and statutory bodies failed to reach this gender benchmark. And the Equal Opportunities Commission tells us that further measures are needed in that regard. So against that background, can I ask, is the Hong Kong SAR government satisfied with these results, and do they intend to do more in this regard? Issue 10 concerns the mechanisms for independent overview of the actions of law enforcement departments, particularly with regard to torture and ill treatment. This question follows up on our concluding observation from the previous report, recommending that the investigation of complaints against the police be carried out by an independent body, the decisions of which are binding on the relevant authorities. I am glad to see that since the prior meeting with this committee, the Independent Police Complaints Council, or IPCC, has been made a statutory body, but it remains the case that investigations are carried out by the Complaints Against the Police Office, or CAPO, which is part of the police force, and that the IPCC is advisory. The committee has received complaints about the effectiveness of the IPCC in its role. Its recommendations are not binding. It is suggested to us that the police do not always provide the documents that it requests. And also it's been suggested that the CAPO will not investigate misconduct if the victim does not make the complaint personally, even if attention is brought to a case by others. And that victims are sometimes pressured not to complain. The response to the list of issues says that there have been no complaints of torture or ill treatment received by the police from 2005 to November 2012. This is a surprisingly good record for a police department in any part of the world, and I wonder whether it depends on a very narrow definition of ill treatment. As you may know, the committee considers that excessive use of force by the police raises issues of ill treatment under Article 7 of the Covenant. The committee considers that spraying people in the face with pepper spray raises issues of ill treatment under Article 7 of the Covenant. And it considers that unjustified strip searches of detainees raise issues of ill treatment under Article 7. There are allegations of incidents of all of these kinds with regard to the police in the Hong Kong SAR. The IPCC statistics from 2007 to 2009 list over 1,500 allegations of assault, and it is possible that some of those may rise to the level of ill treatment. It also appears that the IPC sometimes classifies claims of excessive use of force by police under the heading of unnecessary use of authority, and that categorization may skew the statistics. Regarding the other law enforcement departments which were asked about under Issue 10, the response to the list of issues says that there is no independent complaint mechanism for these others, but only the Ombudsman. The response gives us statistics that the Customs and Excise Department received 129 complaints of assault and threat and dismissed all of them as unsubstantiated, and that the Immigration Division has not received any complaints of either torture or ill treatment. Could I ask the distinguished delegation please to reflect on whether this kind of self-reported perfection indicates the need for a more effective complaint mechanism? Issue number 11 concerns protection against torture and ill treatment of people who are being removed from Hong Kong SAR in other directions. And I want to begin first by very strongly welcoming the cooperation that Hong Kong SAR gives to the United Nations High Commissioner for Refugees in this connection. It's a very important contribution to the observance of rights under the covenant that UNHCR receives the degree of cooperation that it receives, although it would perhaps be an even greater contribution if Hong Kong SAR were to take on this role itself rather than delegating functions to UNHCR. I would also like to welcome the new statute formalizing procedures for protection under the Convention Against Torture. Welcome the statute to the extent that the statute reaches. We requested statistics in the list of issues, and none were provided on this point. It said no one has had a torture claim recognized since 2009. And the answer identifies one earlier case involving return to Sri Lanka. Can I ask then, with regard to Sri Lanka, where the government had previously recognized someone is entitled to protection against torture, how many people has the government returned to Sri Lanka despite claims of need for protection since 2009? Is that information available? I said I wanted to welcome the statute regarding the Convention Against Torture as far as it reaches. But I need to point out that the covenant also requires protection against refoulement to cruel, inhuman, or degrading treatment or punishment. And I see that the decision of the Court of the Final Appeal in the Ubamaka case confirms the view that Section 3 of the Bill of Rights Ordinance requires such protection, rejecting an argument that another provision of the Bill of Rights Ordinance, I believe Section 11, might exempt immigration legislation from the Bill of Rights Ordinance in a way which would interfere with the protection against refoulement. I noticed that the opening statement did not mention this important decision. Can I ask, does the government accept the court's decision in the Ubamaka case? And what further changes will it make to create effective remedies for persons fearing cruel, inhuman, or degrading treatment if they are returned to a foreign country, rather than only those fearing torture? Finally, given the unusual situation of Hong Kong SAR as a region subject to the covenant, which is a part of a country that is not yet a party to the covenant, I also need to ask what procedures the government would employ for the protection of persons who feared torture or cruel, inhuman, or degrading treatment if they were to be sent out of Hong Kong SAR to other parts of China. Thank you very much.
Thank you very much indeed, Mr. Newman. And I now give the floor to Madame Waterfall. You have the floor, ma'am.
Thank you, Mr. Chair. Let me also join my colleagues in warmly welcoming this distinguished delegation from Hong Kong. I'm responsible for issue number 7 and 13. In your replies on issue number 7, that's on the domestic violence, you provided us with some numbers. That's what we ask. But we have also information that the number is much higher than you have provided us. There was also a university survey on this violence against women and domestic violence. I don't know if you know of that survey. My question in this regard is, have you included in the numbers you have provided us, have you included the ethnic minorities, the women with disabilities, the sex workers, the migrant workers, and people because of their sexual orientation? I also like to know if the police and social workers are sufficiently equipped to detect domestic violence and violence against women, and how to process such claim. Do you have programs to make women and girls aware of violence against women or domestic violence? Turning to issue number 13, that is on the people detained in psychiatric institution. My question is, how many institutions are there? Because you have a psychiatric institution, but are there other mental health institutions? In your replies, you say that there are about 890 compulsory detained patients. Is that nationwide? Is that all? Are there no other mentally disordered patients in the institutions? Can you give us some numbers nationwide? And in your replies, you also talk about community mental health support services and residential care services. Maybe you can elaborate more on that and what's the distinction? Also between the medical social services, the outpatient treatment program. And have you evaluated those programs? And is the state aware that compulsory detention of these patients can raise issue in violation of Article 7 of the Covenant, ill treatment? And I thank you in advance for your responses. Thank you, Mr. Chair.
Thank you, Ms. Vattenfall. Maintenant, je donne la parole à Madame.
And now I give the floor to Mrs. Chenet. You have the floor, madam. Thank you very much, Chair. I would just like to welcome the delegation from Hong Kong SAR, and there is a long-standing story between the committee and Hong Kong, even prior to the handover in 1997. In 1997 and 2003, on behalf of the committee, I've been there, so I'm familiar with the NGOs represented, and I'm very happy to see here in the room today and to have this exchange of views with them. And I know that protection under the covenant is extremely important for them, and rightly so. I would just like to very rapidly, Chair, ask the delegation to explain some of its answers to some of the questions. To the question concerning deaths in prison, the answer that we heard was that in the period under review, there were 101 cases of deaths in prison. 73 were death by natural causes, and the others, I saw this in the annex, there were suicides and accidents. So, could you please provide some clarifications with regard to these accidents? Because 73 about a fourth of the deaths have not really been elucidated. And what exactly is the reason for these deaths in prison? And why are there 73 deaths from natural causes in prison? That seems a little bit surprising that you could die a natural death in prison. Perhaps you have people in prison who shouldn't be there because they're too ill to be locked up. It seems a bit strange, this figure.
Je voudrais savoir quels sont.
May I ask, what are the reasons for these deaths in prison? The second question, Chairman, concerns the reply provided by the delegation on the crime of torture or harsh treatment. In paragraph 9.1 from the list in English of the replies, we are told that actually the law on torture with regard to those exercising authority doesn't raise any problem whatsoever because it represses the crime of torture only if it is inflicted with intent. So, intentional harsh treatment, what does that mean, actually? And then further on, it says that the use of force is exercised by the persons entrusted with authority, but it seems that here no account is taken of proportionality. It's not just a case of intentionality. But I think there must be a confusion between what is intentional and what is in proportion. It's punishable if, in the act of repression, albeit legitimate, there is total disproportion between the aggression and what is necessary to exercise the state's authority through its agent. So there I find that the reply, perhaps it's too succinct and doesn't actually convey what the delegation really wants to say to justify this act. And as was stated by Mr. Newman, there's no actual complaint. This is 9.3. There are no complaints received by CAPO between 2005 and 2012. Of course, with this kind of concept, it would appear that people are really deterred from lodging complaints. And if torture is only meted out with intent, then they don't have much of a chance. So the conduct of the police perhaps wasn't always exemplary. So perhaps the delegation could go a little further and go into more detail of this response, which is quite succinct. Now, there is a question that was raised on the preventive detention, and the replies only pertain to the statistics, and it refers us to an appendix which is only in Chinese, and I'm sorry, I can't read that. I don't have this appendix in English. Perhaps we could be told what happens to people in preventive detention, what happens to them. How do you break down these figures between the offences, gender, the nationalities of the persons detained, and How long are they in detention? And I'm sorry I can't read the annex, but thank you, Chairman. And I thank the delegation for its replies already given.
Madam Chaney.
Thank you, Ms. Chaney.
Mr. Fatala, you have the floor, sir.
Thank you, Mr. Chairman. I would like also to join my colleague, welcome the delegation of Hong Kong. I will be very brief. I know we have constraint of time. It is to complement the first question raised by Mr. Flinterman in relation to the Equal Opportunity Commission. As it is stated in the reply of Hong Kong, the appointment is made by a selection board, and I would like to know the composition of the selection board. It was also described in their reply how the recruitment process is taking place, and I believe what is described is not really the recruitment process, because it does not describe how the final decision about appointment is taking place for the selection board. What is described is, for me, a kind of criteria and not the selection itself. Therefore, I would like to know also how the selection board takes the decision to appoint the Equal Opportunity Commission members. Thank you, Mr. Chairman.
Thank you, Mr. Fatala, and I now give the floor to Mr. Shani. You have the floor, sir.
Microphone, sir, please.
Thank you, Mr. Chairman, and I would want to also extend my gratitude to this delegation for the very serious engagement with this committee. My points pertain to issues number 2 and number 9. I would like also to dovetail on our colleague, Mr. Flinterman, and ask the delegation to clarify in their response to the question posed by Mr. Flinterman on the compatibility of the existing procedures with Article 25 of the Covenant as to whether the system of functional constituencies meets the criteria of Article 25, particularly the universal and equal suffrage component. And I would also like the delegation I would want to congratulate the delegation for its commitment to move ahead in the process of implementing a system which would meet the criteria, which would fully meet the criteria of Article 25. I would appreciate, however, whether the delegation could provide this committee with assurances that any future mechanism that will be put in place will be mindful not only of the right to elect but also of the right to be elected, and that any plan to introduce this new system will be mindful of paragraph 17 of General Comment 25, which limits the ability of states to introduce limitations on possible candidates for high offices, in particular by reason of their political opinions. As to Article 9, I would also like to touch upon the point raised by my colleague Ms. Chanet on the question of the compatibility of the existing crimes torture ordinance with Article 7 of the Covenant. And I would like to express my concern with the answer provided to the list of issues with respect to the Section 3.4 and the statement by the delegation that there is no intention to apply Section 3.4 in cases which exceed the very narrow circumstances of using reasonable force to restrain a violent suspect. I would want the delegation to explain to the committee how do they regard this very broad exception to the prohibition against torture. How is it compatible with the duty to ensure the rights under Article 7 of the Covenant, and why is it that the state party or the party in this circumstances, why is it not willing to consider formulating a narrower exception to the prohibition against torture, which is an absolute right under the Covenant and under international law. And finally, under Article 9, I would appreciate whether the delegation could provide us with some further information as to a point raised by our sister committee against torture concerning the use of strip searches in detention facilities. There have been recommendations to introduce guidelines which limit the practice of conducting strip searches on detainees. But still we have before us reports by NGOs that this is still a very rampant practice in Hong Kong SAR, and I would appreciate your clarification on this matter. Thank you.
Thank you, Mr. Shani. Ahora doy la palabra al...
And I'd now like to give the floor to Mr. Rodriguez Recia. Thank you, Chairman. And I'd like to thank the delegation of this afternoon. This is a very specific question concerning the treatment of persons. I read in the report, and I've heard it this afternoon, that in Hong Kong there's practically no trafficking of persons, either as a phenomenon or else specific cases. Now, reading what I have before me and hearing what I've heard, I'm surprised that there is no trafficking either of origin, of transit, or of destination. There are reports that would indicate that at least last year there were 12 persons identified as being victims of trafficking. Also, there are other reports that indicate that there are 6 cases under analysis. These are not government reports. But what I'm worried about is when the government says why it wouldn't ratify the protocol to the Palermo Protocol of organized crime, in this case in order to prevent the trafficking of women and children. And I can't really understand the answer they give, because it would mean apparently making the migration policies more flexible, because it would oblige the government to keep on its territory persons that are victims of undocumented trafficking. Now, probably these people are there because of force. I mean, trafficking is not voluntary. And therefore, they don't come under any free access permit. Now, what we need to do is guarantee the physical integrity of these persons. And as long as you can't guarantee their repatriation, then they're lost. First of all, we have to protect their life and their physical integrity, or their integrity. In other words, you can't put migration above the life and freedom and risk of an individual. Could you tell me more why the protocol hasn't been ratified, and especially what sort of steps are being taken to prevent this? Thank you.
Gracias, señor Rodriguez.
Thank you.
And that's the end of my list. We will now take a 10-minute break to permit the delegation to organize its replies to us. And so with that, I suspend the session until 5 to 5.